Is it more advantageous for a former natural-born Filipino citizen who was naturalized as a citizen of a foreign country to acquire the Philippine dual citizenship, or to simply have a permanent resident visa in the Philippines? We'll talk about that after this. Hello everyone, kumusta po kayo? I hope that you are all doing good. If you are new to this channel and you think that this channel can be of help in providing you with useful information, please feel free to subscribe to this channel and to hit that notification bell icon so that you will get notified of our future videos. Maraming salamat po. In this video, I would like to address the request of Mr. Joe Barrow. He is asking if I could discuss the differences between dual citizenship and permanent residency. This is very relevant because there have been a lot of discussions already on whether or not dual citizenship is more advantageous to former natural-born Filipinos who are now foreign citizens. And the more that we dig deeper into the question, it generates more and more questions. In our previous video, natalakay na po natin na isang option for those former natural-born Filipino citizens who are now foreigners who desire to settle or to reside permanently or to retire in the Philippines is to apply for a permanent resident visa so that they can stay permanently in the Philippines. I was referring to the 13G visa or the non-quota immigrant visa for former natural-born Filipino citizens who were naturalized as citizens of a foreign country. Available po ang option na to if the 1-year period of stay allowed under the Balikbayan program is not enough for you. Just remember that the visa-free entry and the 1-year period of stay that is allowed under the Philippine Balikbayan program is still a viable option for former natural-born Filipino citizens who desire to stay in the Philippines for a year or two at a given time. One very important thing that I would like to mention is that there is one less known option for those who desire to retire in the Philippines, which is called the SRRV or the Special Resident Retirees Visa. I intend to make a separate video about this. Sana po ay abangan ninyo. Now, let us go to the differences or distinctions between dual citizenship and permanent residency. In order for us to make the proper comparison, let us go back to the rights and privileges accorded to the Philippine dual citizen and make them as our point of comparison. Number 1, if you are a Philippine dual citizen, you have privilege to travel with a Philippine passport, something that you cannot enjoy by simply being a permanent resident in the Philippines. According to some, having a Philippine passport makes travel to the Philippines easier because you can avoid long queues in the immigration, although to my mind, that really is just trivial. Your Philippine passport may also allow you to enter with ease some countries which you cannot easily enter using your foreign passport. But what really makes the difference, I think, is about the sense of pride and joy that it brings to a person who deeply values his or her original citizenship, his or her being a Filipino. It is something that brings out in a person that sense of nationalism. Number 2, the right to own real property in the Philippines. Kung ikaw ay isang Philippine dual citizen, you have the right to own land in the Philippines. It could be residential, commercial, industrial, or agricultural. The only limitation on land ownership is that you can own up to a maximum of 5 hectares only of agricultural land, which limitation applies to all citizens of the Philippines as imposed by the Agrarian Reform Law. Kung ikaw naman ay isang former natural-born Filipino citizen, in short, a foreigner, you can still own land in the Philippines but subject to the lot size limitations. For residential purposes, up to 1,000 square meters of urban land or 1 hectare of rural land, and that is under RA 8179. And for business or investment purposes, up to 5,000 square meters of urban land or 3 hectares of rural land under BP 185. So if you desire to invest in owning vast tracts of land in the Philippines, you already know which one is favorable for you. But it would be different if you prefer to own just a piece of residential land or commercial land, or maybe just condominium units. Condominiums are subject only to 40% limitation on foreign ownership, so you don't have to become a Filipino dual citizen to buy a condominium unit. Number 3. As a Philippine dual citizen, you can engage in a business in the Philippines without the restrictions that apply to foreigners. For foreigners po kasi, kasama po dito ang mga former Filipinos, you can engage only in business wherein foreign ownership is allowed. Although recent mandatory laws have relaxed the restrictions on foreign investors. You need to check sa foreign investment negative list kung may restrictions pa ang industry na gusto mong pasukin. Halimbawa, kung gusto mong magnegosyo na may kinalaman sa production of goods or rendition of services for the domestic market, kailangan mo ng hindi bababa sa $200,000 na investment or paid up capital. Maliban na lang kung ang business ay gumagamit ng advanced technology and majority ng empleyado mo ay mga Pilipino at hindi bababa sa 15 Filipino employees, in which case the minimum paid up requirement ay $100,000. Kung nais mo namang magnegosyo sa retail trade and you want it to be wholly foreign owned, kailangan mo ng hindi bababa sa 25 million pesos na investment or paid up capital. Kung sa tingin mo ay medyo mabigat ang capitalization requirement na to, your other option ay ang makipag-business partner with a Filipino citizen nang sa ganun hindi mag-a-apply ang requirement na to. Or you can put up a corporation with lower capitalization, but remember na ang maximum na shareholding na pwedeng ma-acquire ng foreigner ay 40% lamang. Meaning, as a foreigner, you can own only up to 40% of that company. If you want to know more about the restrictions on foreign business ownership in the Philippines, I will put the link for the copy of Executive Order number 175 and the links leading you to the laws affecting foreign investments in the Philippines sa description box ng video na to. Number 4, the right to practice one's profession. Kapag na-retain o na-reacquire mo na ang Philippine citizenship mo under RA 9225, pwede mong ma-practice ang profession mo sa Pilipinas provided that you get your license from the Professional Regulation Commission or PRC, or in the case of lawyers, from the Supreme Court. But if you stay as a foreigner, you cannot engage in the practice of profession na nakalista sa negative list na binanggit ko kanina. Maliban na lang kung may agreement ang Pilipinas with the other country on reciprocity, meaning pinapayagan din ang mga Pilipino na mag-practice ng nasabing profession sa bansang yun. Among these professions are accountancy, criminology, agricultural, civil, electrical, and electronic engineering, geology, dentistry, optometry, and midwifery. You will find a complete list in the Executive Order number 175, and the link is in the description box of this video. Number 5, the right to vote during election. If you are a Filipino dual citizen, pwede kang mag-participate sa electoral process ng Pilipinas. You can vote during elections. Hindi ito pwedeng ma-exercise na isang foreigner. As a matter of fact, under the Philippine election law, ipinagbabawal sa mga foreigners ang sumama sa mga partisan political activities at makialam sa electoral process ng Pilipinas. A foreigner can face deportation and blacklisting once found guilty of violating this rule. So even if you are residing in the Philippines as a foreigner, you have to exercise self-restraint when it comes to partisan politics kahit na ikaw ay isang former Filipino citizen. Number 6, the right to be elected or to be appointed to a public office. A foreigner or a former Filipino does not have this right kahit na nakatira pa siya sa Pilipinas. For a Philippine dual citizen, pwede siyang tumakbo sa election or ma-appoint sa public office pero kailangan niyang i-renounce ang other citizenship niya. Also, that right to vote or be elected or appointed to any public office in the Philippines cannot be exercised by or extended to those who are candidates for or are occupying any public office in the country of which they are naturalized citizens, and or are in active service as commissioned or non-commissioned officers in the armed forces of the country which they are naturalized citizens. When it comes to taxation, a dual citizen who resides in the Philippines can be taxed on both income from within and outside the Philippines. But a foreigner or former Filipino who resides in the Philippines is taxable only on the income from within the Philippines. Kung kayo po ang tatanungin, which one would better serve your need, your plan, or purpose? Would you rather become a permanent resident but with foreign citizenship? Or would you choose to become a dual citizen? Or would you choose neither of them because you are satisfied with the privileges that you can avail of under the Balikbayan program, such as the visa-free entry and the 1-year stay in the Philippines? Or you have no plan at all of visiting the Philippines, the reason why for you none of these options would make any sense? Please feel free to drop your comments or reactions in the comment section below. My only request is, let us be polite or courteous in making our comments or reactions. I hope that you have learned something from this video. If you haven't subscribed to this channel yet, please don't forget to subscribe to it and hit that notification bell icon so that you will get notified of our future videos. Always remember, ignorance of the law excuses no one from compliance therewith. I will see you in my next video. Ingat po kayo.